Welcome to Queen City News Plus. You are watching Order in the Court today with Brian Blakely and
I'm Chief Legal Analyst Khalif Rhodes.
All right, good to see you, my man. Court is in session. We've got three topics, as we always do here for the next 25 minutes or so. And the first one today, Khalif, it's making the news since Friday, really going into the weekend, and that is about the DOJ wanted to criminally indict Fed Chair Jerome Powell for comments that he made back to Congress regarding the makeover of a building that they have there in Washington.
Powell says this is pretext for wanting to get back at the Fed for not pausing and not cutting and not lowering interest rate at a pace that has been demanded by President Trump. The core constitutional issue here is whether the executive branch may use criminal process to pressure the independent monetary authority over policy decisions. I know that was a mouthful, but that's what the question presented would be if this case went before the Supreme Court, not the whole Department of Justice investigation, which I think ultimately when it gets there, they will review what was said before the committee and they'll make a determination of whether you were truthful or not. And you can go and look at the testimony. This is something where you can pull the transcripts. South Carolina's Tim Scott raised issues with what he said during those hearings and talked about, hey, there's excessive spending being done by the Fed chair, specifically with this renovation. It's already billions. They're wanting more billions of dollars that are taxpayers' dollars, and they're trying to find ways to cut down on the spending. But if you move away from that issue and you talk about what Jerome Powell is saying is the crucial crux of the issue, it's can the federal government, specifically the executive branch, specifically address the independent authority of this monetary agency. And right now, that is going to be the question. It seems like for forever, they have been hands off, that is at least one agency that no one was attempting to touch. But now this seems like the president is attempting to say that I will be able to exert my authority over that agency as well.
Is it a fireable offense for Powell to be terminated before his Fed chair, which is ending in May, for Trump to do so before that? And also Powell has a Fed governor's chair until February, believe in 2028.
Yeah, so as you hit on it, he'd have to the end of his term is 2026. He has till 2028 for him being a member. Remember, he was appointed by Obama, but President Trump in his first term nominated him to be the chair. President Biden in his presidency nominated him again for his second term, and then that term is coming to an end in 2026. What I will say is that it is a fireable offense if you lie before Congress. Yes, the removal of an independent agency chair can be done through removal for misconduct. And that's pretty clear. Looking at the Humphreys executor case, it upheld limits of presidential removal of independent agency officials, but it outlined within that case that it had to be for cause, it had to be for misconduct. And so if you're attempting to remove him for coercion, for policy disagreements, no, that's not going to be for misconduct. But if it's something like lying to Congress, then clearly that would be misconduct, and it would be able, the president then would be able to remove him. But I think this will be potentially a moot point. We're in January. We're a few months away from his term ending in May.
Well, one of the things, too, that came out with Jerome Powell, he came out with a video himself saying that this was political retribution for him not lowering the interest rates. Is that a fireable offense in itself when you talk about misconduct?
No, I mean, I think he's within his right to make any type of statements. Department of Justice is bringing a subpoena against him specifically, and they're wanting him to address previous comments that he's made in front of Congress. So he's taking his case to the court of public opinion, and to this is something outside the scope of normally what Jerome Powell would do. Someone that comes off as extremely measured, extremely understanding of what his words mean to the market, and anything that he says can oftentimes shift the market in hundreds of point moves. And so he's made it his point to ensure that he doesn't say anything. When he makes his remarks, they're always, calculated and measured. This was, I think, more in the line of, okay, I feel like I've been attacked personally, and I'm going to address those attacks. Powell strongly rejected the premise of the probe, calling the renovation issue a pretext. He argued that the real motive is political retaliation, and he framed this investigation as a threat to the Federal Reserve independence, not legitimate congressional oversight. what you're saying is if Congress has an issue with the money that I'm spending, and I've already went to Congress and said the statements and made statements in front of Congress, if Congress thought that something I said was a misrepresentation, that body should be bringing me back to address whatever they thought was the miscomings or the misstatements, as opposed to the Department of Justice on an attempt to say that I am now defrauding the American people. That's his argument. On the Trump side, what they're saying is these statements, if they were false, yes, this is criminal exposure. So to your original question, a criminal exposure would clearly fall under misconduct, which now would allow the president to remove him for cause. And we've seen the president attempt to remove individuals that are heading up agencies already. Every agency that you can think about within the alphabet soup of agencies has had movements throughout this second President Trump's term. And I mean, even on the Fed itself, with Cook attempting to be removed. So there are a number of folks that are attempting to be moved throughout this presidency. Excuse me.
Bless you. And you know, it's it's coming up 2 weeks when the Fed is expected to meet again, where they are expected to make their decision on whether they're going to lower interest rates or not. And could that be legally used by the president in any way, shape, or form?
I don't think so. I mean, what I think is that Jerome Powell recognizes that there are a number of things at play here. And those conversations, if you've been following this, is nothing new. This didn't happen overnight. The debate over to lower, to stop, to pause, any of these things that the Fed has been doing over the last maybe 2 years has been at issue. And so, again, this is not something new. I think that they will continue to make the recommendations, as he stated earlier in his comments, that we'll make the recommendations based on the assessment that we do on the information that's provided in front of us, that it won't be based on the motion and it won't be based on an outside influence. And that is something that he is attempting to maintain, the independency of this agency. And that's what's at stake. If this ever gets to court, the Supreme Court will have to address it. And they've kind of touched on it a little bit. When we've had some of these other alphabet soup agencies go in front of the Supreme Court, they've talked about limiting their ability and expanding the president's ability to remove individuals. But they have been crystal clear that when we're talking about all these other agencies, we are not talking about the Federal Reserve. They wanted to be clear that, yes, this discussion that we're having, we're addressing whether the president can remove cause or no cause, that their conversation was not talking about the Federal Reserve. This is going to open up a new can of worms. And now if this issue comes and he is ultimately removed early, yes, this Supreme Court will have to address, did the president even have the authority to do this?
All right, certainly a story we're going to keep tracking, especially as it comes up in 2 weeks when the Fed is going to be meeting and see what transpires over that time, especially in regards to this possible criminal indictment of Jerome Powell. You just also mentioned the Supreme Court. That is our next topic here on Queen City News Plus. You're watching Khalif and Brian on Order in the Court. We'll be right back with more. Welcome back to Order in the Court. You got Khalif and Brian here. Second topic that we're talking about today, Khalif, is Supreme Court justices are back from their winter break, and they're taking up a couple of cases that are related to transgender athletes. And these decisions here could shape how and could interpret the courts, how they interpreted equal protections under Title IX and transgender rights. Let's talk a little bit about it.
You are all over it. So the first case comes out of Idaho, Little versus Heacock, and it's a case where Idaho enabled this law called Idaho's Fairness in Women's Sports Act, House Bill 500 out of the state of Idaho, a law that bans transgender women and girls from competing on girls' and women's school and college sports. A transgender woman and former college runner brought the challenge after being denied and barred from trying out for a women's sports team under Idaho law. The key question in that case is whether the state ban violates the Equal Protection Clause, as you mentioned, and whether the ban violates the federal civil rights law, especially Title IX. This other one, this West Virginia case, even though they sound the same, they are different. West Virginia case is similar law that bans transgender participating in girls and women's sports teams in public schools. Becky Pepper Jackson, the transgender teen athlete, sued on behalf of her right to compete on a girls' sports team. These two distinct cases involve different state laws, but both ask the Supreme Court one crucial question, and that's whether these bans that exclude transgender girls from female sports teams are constitutional. and compliant with federal civil rights protections. Title IX, we're talking about the Educational Amendments of 1972 and Equal Protection Clause of the 14th Amendment. For folks that are historians of the Constitution, they'll recognize that this case will be decided on a couple questions that will be presented to the court. The court must first decide, well, does excluding transgender girls from sports violate Title IX? Does it violate equal protection? What level of scrutiny applies? And how much deference do the courts owe to the states when regulating these things? And so the most famous case that I can think of is, with RBG, her case before she made it to the Supreme Court was a case where they challenged this very question. It's on the basis of sex. If the ban discriminates solely on the basis of sex, and it's a federally funded educational program, you can't do it. And that is going to be the question that the court is going to have to deal with. And this has been one when I often say on here that you need good facts, a good court, and good timing to bring something before the Supreme Court. Well, you got a court that wants to address this. They've talked about it a number of times. You have good timing because this conversation, these questions are in the air about transgender athletes participating in sports. And so now, do you have a court that is going to rule the way that they've been tipping their hat that they're going to rule? And I think only time will tell. But when we hear oral arguments on Tuesday of this week, I think we'll figure it out right there on the spot. Based on the questions that the justices ask, you will be able to know which way they're willing to go.
Now, having these, we're filming this on Monday. Oral arguments are going to be on Tuesday in Washington, in the nation's capital, at the Supreme Court. You're looking at right there. When could we expect any kind of decision on something like this?
A case like this is going to take 6 months. They'll hear oral arguments, and then every side will go back to their respective sides in terms of the justices, because you got to think about what happens. First of all, for a case to get cert, for it to be argued in front of the Supreme Court, you got to get 4 justices that want to hear the case. So you get those 4. Those 4 justices aren't saying, yes, I want to decide one way or the other. I just want to hear this case. But once they walk into the room, I've clerked for enough judges to recognize when they walk into that room, the judge is already understanding the way they want to be able to rule. So now you're listening to arguments, and hopefully you're hearing things that support what you're wanting, the way you want to rule, or you're hearing things that tear down the way you're wanting to rule. So you listen to the arguments that the judges, the questions that the judges ask, and most of the time they're going and directing the conversation in a way that they can get out, this is the point that I was thinking that we would address. And then after oral arguments are over, someone will write the opinion of the court once they determine the way the court's going to go. But in that interim, every justice is already thinking about case law and thinking about precedent and thinking about the way that they want that case to go. It's a seminal case. It's a Title IX case, and the Title IX language is under the Bostock v. Clayton County, where discrimination based on transgender status inherently involves sex. That case right there is the most recent case that I think will have a strong bearing on this case.
You brought up something there about justices kind of already know about where they're going. You have the oral arguments that are going to begin on Tuesday. How much do they matter?
A lot. I remember when I clerked for my judge in Michigan's circuit court judge, which is equivalent to our North Carolina Superior Court judge, he pulled me to the side when we get ready to go to oral arguments, and he'd say, listen to what the attorneys say. And he on the record, I remember him telling the judge, attorney one time, he said, make sure that you answer the question that I asked you. And why is that important? You've already submitted your brief. I've already read your brief. I already know what you're arguing. I already know what the other side is arguing. Now I may need help navigating what you've argued. And so oral arguments help me navigate your argument, but they also help me either shoot down ideas of the way I thought you were going, or they'll help me lift up ideas that you've already presented inside of your briefs already. And outside of the briefs that you have, as well as the two parties, you'll have these amicus briefs, these briefs that other people that are outside of the case have submitted. So there is a number of things that have been submitted before we get to the day of the hearing. So you asked the question of, are oral arguments important? Yes, they are the most important because they guide, they clear up, they make sure that anything that was muddy is no longer muddy, that water can now be visible, or sometimes they hurt. A justice may say, hey, I was thinking this way, and now based off what you said, all right, I'm thinking a whole different way. So yes, the oral arguments are probably one of the most fascinating parts of the legal process because you can see in real time and hear in real time how a justice is thinking. And so you'll have these states making these arguments and saying, listen, they'll argue that sex in 1962 meant biological sex. Congress expressly allowed separate male and female terms. That's what they're going to argue. And they'll attempt to short circuit that Bostock, which is employment outside of education. They're going to say that Bostock should not apply to us in this case. And so that's why I say if this rendition of the Supreme Court falls back on Bostock and the petitioners are able to prove that this is solely based on sex, the court, based on precedent, should rule in favor of the challengers. However, this court has made the indication over the last few rulings that they're willing to go away from Bostock, which is something they just ruled on.
Yeah, so it's interesting that it has that much sway because there are people that the justices do come in with their minds kind of made up in some degree, but they could be there to completely have a different decision than what they thought they would be.
Yeah, I mean, you got two blocks within the Supreme Court. You got the conservative block that's skeptical of extending Bostock. You got the concerned about redefining sex. They have strong federalist instincts. But then you have the liberal block that sees this as a straightforward sex discrimination case. What will be at issue is, does the conservative side view transgender sex as defined by Congress? And if they don't, then that straightforward sex discrimination argument is out the door.
All right, we're going to wrap up that one. Then we're going to have another case coming up, and it's going to be involving 9/11 and free speech. You're watching Order of the Court. Khalif and Brian, we'll be right back right after this. Welcome back to Order in the Court. You got Khalif and Brian here as we're talking about our last subject here as our court is in session. And Khalif, it's in the Federal Appeals Court on Friday. Last week, appeals court had thrown out all remaining criminal convictions on an Islamic lecturer, Ali al-Timimi, from Northern Virginia, who served about 15 years of a life sentence for soliciting treason by encouraging other Muslim men to fight overseas in the wake of the 9/11 terrorist attacks.
Served 15 years of a life sentence, later released to home confinement during COVID. So we have so many different issues that this case touches on. I mean, COVID, September 11th, attacks, free speech, constitutional issues, sentencing guidelines. The judge at the time when she sentenced him after he was convicted said that these are draconian types of sentences, but her arms were bootstrapped, the hands were bootstrapped because on the federal court, they're structured sentencing. For you to be able to deviate or to go upward or downward departure, there has to be something significant. But in this scenario, there was no ability for the judge to do any type of departure upward or downward. And so the sentence was only life. And so in this scenario, the judge at the time addressed the concerns. But as you mentioned, the Court of Appeals unanimously vacated all remaining criminal convictions for this individual. And I like to just read what the judges say, because for me, it's the easiest way to recognize when something has been done wrong. It's you can look at it from afar and say Monday morning quarterbacking it, 15 years later, 20 years later, you guys didn't get it right. But these judges that listened to this case had an opportunity to say something here through their words. I often say that speech is free, but the consequences for speech are not. That oftentimes people make statements and they may lose their job. And you have an opportunity to say things that are on your mind, but there are connected to consequences that sometimes you may not want. In this scenario, what I appreciate is the judge saying a couple of things. Plenty of speech encouraging criminal activity is protected under the First Amendment. The First Amendment protection does not depend on the popularity or the palpability of the message conveyed. This is the best part. On the contrary, it is most vital when speech offends, disturbs, or challenges prevailing sensibilities. What the court is saying is our First Amendment protections are there not just to protect stuff I want to hear. We wouldn't need First Amendment protections if it was just there to protect all of the speech I like and get rid of all the speech I don't like. We have First Amendment protections, and this court articulated better than I ever could. We have these protections to protect the stuff that you don't like, the stuff you disagree with, the stuff that you think is offensive, the stuff that you think disturbs your core. Someone has the ability in our country, that's what makes us great, because they can say something you don't like, and they have a constitutional protected ability to do that.
Yeah, it's interesting to see what he said there. Judge James Wynn at that federal appeals court was the person who made those comments, and it certainly makes you think about a lot of other discourse and things that we see with regarding free speech, the attacks on free speech around the country, internally here in the United States, as far as what is free speech and what isn't.
Yeah, I mean, that comes out a lot. I mean, first of all, the government cannot chill your speech. It can't limit. It can't stifle. It can't stop your speech in public forums. That's the first thing, right? And so the argument that the court will need to make is, or analysis is, am I talking in a public place? Is it a public forum? Is it a form of discord? Or am I talking in a private setting? That's before we even have any constitutional analysis, is this speech in a public place? And if it's not, then this argument doesn't even matter. If you are doing something where you're attempting to limit the speech, the government has historically been able to limit it on something called time, place, and manner. I can't limit the context of what you're saying, but I can limit where you say it, when you say it, what time you say it. That's that time, place, and manner. But if I'm attacking what you say, historically, the courts will say that it is protected. Content neutral is the argument. If you're attempting to go after someone's speech, and you're going to be content specific and say, I want to get rid of that specific speech, then you're going to have to be narrowly tailored. You're going to have a compelling public interest. This is the highest type of scrutiny that we have in the legal system. It's called strict scrutiny. That constitutional protections that are there for that type of speech is extremely high. And so the court went through an excellent analysis here, making sure they recognize how important this type of speech is. And one thing I like is that they went on and addressed President Trump's speech in January 6th. They said during oral arguments that speech to illustrate how exhortational rhetorical rhetoric can blur the lines between protected speech and criminal conduct. They use that speech as a basis for releasing this man, or at least vacating his criminal convictions, saying that speech right there is an example of speech that has not crossed the criminal line and is able to be able to say people can agree or disagree with it, but you are constitutionally protected to make that type of speech.
It is certainly an interesting case that creates a lot of dialogue, especially here between us today. And thanks for watching here on Order in the Court. You got Khalif and Brian, and we appreciate you. And that's it for Queen City News Plus.
Queen City News Plus. Just search Queen City News on your smart TV's app store.